and welcome to the Divorce Lab. We're a group of independent professionals working to help educate the public on various topics related to divorce. I am Carrie Goldring, a certified divorce lending professional who specializes in mortgage planning.
And I'm Mark Avezai. I'm a certified divorce financial analyst. I work primarily in Troy, Michigan.
Hi, I'm Jim Chryssikos. I'm a family law attorney and mediator located in Troy, Michigan. So let's get started with today's show.
Hi, I want to welcome you to the Divorce Lab, where we are going to discuss in kind of an interesting way the collaborative divorce process, which we have already started talking about. So in our episode today, Mark and I are going to play the married couple who's getting divorced, and we're going to try to go the collaborative process and ask questions so we understand how this works. So Peter, welcome again to help us with our podcast.
Thanks a lot for having me again. I'm happy to be here and continue the discussion.
Yeah, it's good. So, okay, so I'm married to Mark. Peter, I want to hire you as my attorney, and you have brought up collaborative divorce, and I've talked to Mark about it, and he's not really sure. What do I do?
So I think it would partially depend on where his reticence comes from, I think, but assuming it's kind of so let's say it's issues with, oh, well, isn't that going to be really expensive, or I don't really understand what that means. Those are situations where it just calls for a little bit more information. And so, I would say either you or I could have a conversation with him about how collaborative works a lot of efficiencies into the process, like we talked about a little bit last time. Instead of having two camps that are both kind of working up the case, when you do it as a team in a collaborative case, it's not doubling the work in that way. So, maybe that speaks to efficiency issues. And, maybe if he doesn't understand what it is, maybe having either you or I show him the CPIM, the Collaborative Practice Institute of Michigan website, where there's a lot of really good kind of basic information about what does this process look like. And, I think people, when they know about it, they like the idea of it. And so I think it'd probably be a kind of closing the information gap type of process usually. Hopefully it's not a situation where he's already hired someone that's not a collaborative divorce attorney, but even if he has, he can still get the information, and maybe that divorce attorney, maybe isn't the one for the case once he realizes what once Mark realizes what it's in for, and there's nothing saying that you can't, change midstream or go a different option.
I have a question. So if he talks to you, does he have to worry about like you playing tricks on him and getting information and using it against him later?
Well, so it's important when an attorney talks to the person who's on the other side of a case, the other spouse, it's important that those conversations don't even come close to going into the range of giving legal advice or anything like that, because that's considered a conflict of interest. And so I would keep the conversation very kind of procedural, informational, kind of process oriented as opposed to substance oriented. I'm not going to get into, here's what I think you guys should do with the house or anything like that. It's more going to be, this is how this process would look. So no, I don't think that's should be much of a concern, though I can understand that.
So to be clear, Carrie has asked for the divorce and I don't want it, right? So I may or may not be blindsided to some degree. Mm-hmm. Peter, in speaking with you, as long as I'm not revealing any specific information, I should probably be able to feel fairly comfortable that I can talk to you in general terms.
Right. Yeah. General kind of process oriented terms. Yeah. I think that's a fine kind of.
I'll just jump in real quick because I do some mediation work too. And I've worked with other mediators, and there's an expression that I always kind of steal, and that is, I am not your attorney. I can still provide you information, but I can't provide you with legal advice. So if I'm just providing legal advice to another spouse, not the one that I represent, but the other spouse, I'm still fine. It's ethical. There's nothing alarm. I mean, frankly, it can be a one-way discussion. You just need to listen. And if you have a question, great. But generally speaking, if I'm talking to the other spouse, I'm not asking you to reveal anything or tell me about what you want out of this. I'm just providing information about the process.
And how does he know it's truthful what you're telling him?
Then we get to the next step, which is how to put the other spouse in contact with other collaborative attorneys who can give him the right information.
So that was going to be my next point. So Peter, I call you and I say, hey, Peter, I know you're Carrie's attorney, right? I am talking to an attorney or a few attorneys. I've done some interviewing. Carrie's brought up this collaborative process. It sounds interesting. I don't believe any of the people that I'm talking to have this training. What's next?
Yeah, so the CPIM website is again a great resource because it has a searchable function on there where you can go on there and look for an attorney, even if you want one just in your geographic area, you can search on there. So depending on your level of comfortability, Mark, I could either say, look, here's several attorneys that I've worked with in the past that I know to be good. Here's their information. If you'd like, these would be recommendations. If you'd feel more comfortable kind of working more from a clean slate than from my recommendation, just head over to the CPIM website and do a search, and you'll come up with some options there. And there's links to their websites, and it's easy nowadays to look up reviews for attorneys and things like that. So it's definitely not kind of a just open the phone book kind of, old school process. It's easy to steer yourself in the right direction.
Okay, so let's say you start talking to Jim.
So obviously if we're engaged now and Jim is my new attorney. How do you guys then decide who is going to be part of the collaborative process? How do you decide who the coach is, who the financial is, when and if you bring on a mortgage person? How does the team assemble?
Well, first thing I would do is once you've retained me, knowing that Peter's already been retained by Carrie, I would then pick up the phone and call Peter and say, Peter, I just wanted to let you know I've been retained by Mark. He's interested in doing this in the collaborative process. We'll schedule a time to have a brief meeting, phone call, to talk about the case a little bit, what we know, and we'll start to discuss other professionals that we think might be a good fit. My personal preference is not to overwhelm the clients with a flood of financial neutrals, a flood of coaches, and let them figure it out. Usually I like to give them one, maybe two names of people that they can reach out to and see if they click after I speak with Peter. But yeah, I think overwhelming them with too many names and contact information is a little much, unless they specifically ask for that. If somebody asks me, give me 3 or 4 names of financial neutrals, I'm not going to say no, but I'll say, are you sure you want that many? But sure, but otherwise I would just give them 1 or 2 and say, if you aren't feeling good about this, or the comfort level isn't there, let us know. We can give you another name or 2.
Mm-hmm.
How do you feel about that, Peter? Is that?
Yeah, I agree. And one of the nice parts about, you and I, Jim, have both been attorneys practicing collaborative divorce in this geographic area for quite some time. We've got a pretty decent concept of a lot of the professionals in the area, kind of like what their particular strengths and weaknesses are, things of that nature. So, I mean, I feel like we're in a pretty good situation to be able to say, okay, this is something that we would do on that phone call or that meeting between the two, you and I, like we talked about, is we would say, okay, this is probably a case where we could really use a coach that takes, maybe a more of a firmer hand on the tiller kind of approach, or this is one that's going to require a financial that has, experience also with, business valuations, or who knows. And we know who those people are in the area. And so that's why it's helpful, both not just to avoid overwhelming the client, but also because in a lot of ways, we're in a good position to be able to kind of hone in on who might be a good fit for the team.
Does any emotional factor come into play, right? Let's say, for example, I've been on plenty of cases where it is literally all women across the board, women attorneys, women coach, women, I've seen, women financial, and there's just the guy, the husband is the only male in the room. Does that come into play for you guys at all, ever?
That's a good question. I mean, specifically the gender issue, I don't generally usually make an issue out of that unless a client makes an issue out of that to me. But yeah, it's temperaments and kind of philosophical approaches and things like that. Yeah, you want to match those. You want to make those make sense, and not every professional is a good match with every particular client. And so yeah, it's good to be attuned to those kinds of things. And maybe I should pay more attention to that gender aspect. I don't know, but those types of things, the client's comfortability and the overall dynamic are important for sure.
Yeah, I agree. I don't focus a lot on the gender dynamics unless somebody brings it up, a client brings it up. But I'm more interested in the complexity of the case, the personalities, and whether I think they'll click. That's definitely more what I'm worried about or thinking about.
I want to backtrack because I have a good basic question. So you both mentioned retained me. And then we're doing this as like a team. So if we retain you, what does that mean? And if it involves money, then whose money is it?
That's a good question. So retaining is a fancy word for hiring, right? And so when you're forming a collaborative team, a traditional kind of collaborative divorce team is the two divorcing spouses. They both would each have their own attorneys, and then you would have a financial professional and a mental health professional who acts as the coach. And that's usually kind of who you start with, although oftentimes someone like you, Carrie, who's got the mortgage aspect of it and the should be involved from day one. But the basic idea is all of those people do indeed need to be hired. And so each professional will have their own agreement for services, or a retainer agreement that they will have the client sign. The only exception to that is the attorneys only sign a retainer agreement with their own client, but generally the neutrals would be retained by both parties. What's important to know from the whose money it is standpoint is, legally speaking, the expenses for a divorce are considered marital expenses. So what that means is it's perfectly fine to use normal marital assets, marital money, to hire the marital professionals, even your own attorney. So you don't necessarily need to have great Aunt Ethel on the side, lending you money to pay for your attorney. It's fine to pay for it out of the joint account, just like you pay for groceries or the house payment or anything like that. It's a legitimate marital expense.
So, question, what if there's a difference in cost between my attorney and Carrie's attorney? This happens frequently, actually, right? And so, to your point, does she have to pay the difference? Do I have to pay the difference? Is it then still all marital, to your point? Do I get credit for using a cheaper attorney?
I was going to ask that same question.
That's a good question. Although it hasn't come up for me as much, but maybe I've just been lucky enough to dodge some landmines that are out there. But I mean, generally you don't see that as an issue. Like, what I do see sometimes is that attorneys will try to avoid that on the front end by matching their fees to one another, saying, what did you charge for a retainer? Let's try to match our fees so that doesn't become an issue. But even if that kind of conversation isn't had, yeah, it's not uncommon that maybe one of the clients, talks more to their attorney than the other, and so I guess I would say there's no hard and fast way to deal with it. Normally it does kind of just come out in the wash. If someone wanted to make an issue out of it, presumably they could. I would say one of the nice parts about collaborative, though, is that in a collaborative divorce, there is less time spent between the attorney and the client kind of strategizing on the side and things like that. It's more where the conversations are supposed to happen at the table with everybody. And so there's less of an opportunity for a lot of kind of time consuming strategizing going on the side where whereas like on a traditional litigated case, you might have a, let's say, husband it needs a lot of hand holding from his client, from his attorney. So they're talking every day, and wife, doesn't need that. And so wife isn't talking to her attorney all that often. And then lo and behold, when they get to the end, husband's, attorney's fees have been 3 times as much. That can be problematic, but that is more common in a traditional litigated case than one where it's kind of where the team is operating together and usually basically working at the same time.
Yeah, I would say the difference in the cost between attorneys in most collaborative cases isn't too extreme.
Mhm.
And that's why it's very rarely an issue. But I think what Peter said is correct, that the cost of all the professionals to get through the process is typically viewed as a marital expense. And so if one attorney spent a couple thousand or charged a couple thousand more than the other attorney, when you look at the final numbers, most people, not everybody, but most people would just look at that and say, well, that was the cost of getting us to this endpoint, and it'll be shared.
Good.
Doesn't mean that a person can't take the position that Mark just mentioned and say, hey, my attorney was $2,000 less than your attorney. Shouldn't we discuss that? And we can discuss it. We can absolutely discuss it. But I think most people would look at it and say, it's not worth the time and effort it's going to take to debate it.
Right.
Because I do think, like Peter said, we're tracking our hours are pretty close usually, unless it is that extreme case where one person needs a lot more attorney assistance than the other. But even then, I think most of those cases we're kind of letting the professionals do some of that work, the financial. Because why does that client need more, as you said, Peter, handholding? Maybe it's because they're concerned about money when the divorce is over. Well, that's more of a financial neutral issue.
Mhm.
Are they more concerned about the custody or parenting time issues? Well, that's more of a coach issue and working out a schedule that works. So it's generally going to get worked out in that way.
Mhm.
Yeah, or if there's a housing question, right? They're talking to Carrie
Yeah.
ahead of time. But yeah, no, I totally agree with everything you guys said. When we're working in the collaborative space, I think we have a lot as financial neutrals, have a lot of conversations with the clients, and we let both spouses know, hey, we're probably going to be talking to the non-financial spouse a good amount more than we're talking to you, and you want us to do that. And the reason you want us to do that is you want them to feel educated, knowledgeable, and comfortable with the decisions that are going to be made, and it's going to be better for you. And
I just want to say one more thing before we move on, and that is that issue that you raised, Mark, is far more problematic in litigation.
Mhm.
Yep.
In litigation, when people don't have that settlement-minded approach throughout the process, like we do in collaborative, where the attorney, I've had cases where the other attorney's fees were 100,000 more than my fees. Okay, how do you resolve that? Well, in that case, an arbitrator did. But the point is, you rarely see a significant difference in collaborative because we're all moving we're all in the same ship, kind of moving things in the right direction. Litigation's where that is a much bigger problem.
Mhm. Mhm. Yeah, that's 100% right. And that kind of leads us into one of the points that I wanted to talk about that we didn't get to last time was, so if in our little sequence here, so after the team has been assembled and all of the professionals have been retained, um, it's often common for the neutral professionals to then kind of take the ball and run with it a bit. And again, that's where some of those efficiencies are built in. So, for example, and this is again after everyone's been retained and also after a participation agreement has been signed, which we can talk more about. But then Mark might reach out to the spouses and say, look, here's some basic financial information I need from you guys. Why don't you get this to me? And then let's set up a meeting for us to go over it together. And I'll have everything kind of analyzed and we can look at a spreadsheet together. And that may happen before we all meet. And the coach may reach out to the spouses and say, what are you guys thinking in terms of custody? Oh, you want to do 50-50, but you're not sure, you know, what you want that to look like. Okay, well, why don't we get together and let me show you some options of how people do that, whether it be week on, week off, 2-2-3, 2-2-5, and then they'll get together. And then we realize, okay, we got to figure out if wife wants to keep the home, how, you know, is that even going to be possible for her? What type of support will she need to be able to qualify? Okay, let's have her get with Carrie. And that can all happen before we even get all of the professionals and the clients together for a meeting. And so, you know, you have the opportunity to build those efficiencies by working kind of on the sidelines with whoever is kind of pinpointed to that aspect of the case, so that when we get together, it's like, okay, great, nice to see everybody. Where are we at? And then Mark can say, well, here's what we talked about on the financial aspect. Here's these ideas we came up with. You know, these two really like this kind of concept. And Carrie can say, I got the mortgage part of it all worked up. Here's what the options are, you know. And so you can be really efficient that way, which is one of my favorite parts about collaborative.
Mark and I can talk off, right? So not Mark and I as the married getting divorced couple, but Mark and I as the professional. So he could say, you know, I could say to him, okay, spouse 1 wants to keep the house, spouse A doesn't, but I need these assets and this, you know, how is this going to work logistically? And he could say, well, I have this and we have this, and they both are comfortable doing that. And then we can kind of maneuver and work all the different puzzle pieces, and then present more of like what you said, option A, option B, knowing what is and isn't possible, as opposed to just throwing all this information at somebody. And then they have to kind of say, oh, well, I want the house, so I need this much support. And someone says, no, you can't get that much support, you know? So we're kind of helping them get their conclusion that they want, as opposed to them trying to figure out and untangle everything.
Yeah. I don't remember if we talked about this last time or not, but some trainers that we had here in Michigan not too long ago brought up a really good point that I have had many opportunities to use in the short time that I've even had this point, which is the concept that in a collaborative divorce, it doesn't mean that the two spouses have to be cooperative or collaborative per se. What it really means more so is that the professionals on the team are going to be working in a collaborative way. And I just wanted to throw that in here because what you were just describing and what I was describing is exactly what that looks like. And so, you know, that's the professionals will collaborate, will all be kind of you know, rowing in the same direction. And so even if the spouses don't get along very well, even if they, aside from the meetings, they don't even see each other or have any interaction with each other anymore, the difference between having all of the professionals working collaboratively versus a litigation case where each client has their own attorney and those attorneys are very much in their camp or their camp, and it's this adversarial relationship. That's really what collaborative divorce means. And so, you know, I just want people to not be scared away by the concept of, well, you know, I don't know how collaborative me and my wife are, you know, it doesn't, around the house, it sure doesn't feel very collaborative. That's not really what we're getting at with the concept and with the name that we use for it.
And that's similar to something I always say, you know, people, there's the misconception that if we're going to use a collaborative process, we either already have an agreement or we're going to get an agreement real easy. And then the reason they don't go down the collaborative path is they say, well, we're not there. We're going to have too much to fight about, or we've already reached an agreement. Why do we need to hire all these people? And I always tell people collaborative is really the alternative to litigation. Okay. And all you really need to agree on is we want to work together to try to come up with a solution. We want to keep it private. We don't want to spend a fortune in legal and professional fees. And that's really all you need to agree on. right?
Exactly.
If you agree that you don't want this going into a long drawn out court battle and you want to try to reach a resolution, even if you have no idea what it looks like, you can use collaborative, and maybe you should use collaborative. And I don't push cases where people have already kind of got a framework of a settlement into the collaborative process just to say we're using collaborative. No, if they say we've already got an idea of what our settlement's going to look like, so well, maybe you want to use collaborative, but maybe you want to just go to let's draw up a settlement for not using the collaborative process, and we can just file the case with a settlement already in place that you two have reached that I've written up
That's a great point,
or a
John.
mediator has written up.
That's a great point. And I've been doing that more and more. I mean, it really is, an experienced family law professional is going to really try to match the process to where the clients are at and what their kind of priorities are for how they want their process to go. And so sometimes that means a collaborative case, sometimes it means something less formal than that, like you're talking about. Where collaborative really shines is the cases. And this is going back to the idea that, it's definitely kind of a misconception where people think, well, if we're not already on the same page, we shouldn't do collaborative. That's kind of like exactly the opposite, because where collaborative really shines is in cases that otherwise would probably be in trial,
Yeah.
which means like these are the hard ones to settle, the ones where you would be in, months and months and months of gladiator combat and motions being filed and, trial date after trial date. I mean, that's where collaborative really shines is if you do it your case collaboratively instead of litigation, including, up to or including trial, your process is going to be so different. And
But
at that point, it's going to be quite a bit cheaper too, probably.
and avoiding that escalation
Right.
that, oh, you're going to do this, well, I'm going to do that, and my attorney said this, and my attorney said, and then before you know it, you've probably dropped 20,000 each on your attorneys and professionals, and you're staring down the barrel of a trial.
You're further apart than you ever
Oh, yeah.
were. And right. Yeah,
Yep.
exactly.
That's true. And not all trial attorneys, but there are many that I have worked with where sometimes they don't even do the settlement agreement or an offer. They just kind of wait for mediation to take place, and it's the court appointed mediation, which is not the fun mediation.
Yeah, court ordered mediation, like that would be what I would refer to as late stage mediation, where there's a trial date coming up and you have one chance to settle it and avoid trial. And sometimes that's a marathon mediation session because you have no choice. You gotta settle it or you're starting to prepare for trial. That's a much heavier.
Right. I've had phone calls from people at mediation saying, I want to keep the house and I don't know if I can. And the mediator stepped out of the room and I need to talk to you real quick. And it's like,
that's where people feel like they've been pressured or agreed to things under duress. And it happens all the time. I mean, the court has defined it's not duress just because you didn't want to go to trial, but they definitely feel that it was under duress and therefore they're not happy with it. Whereas I think, speaking for myself, and I think Peter would agree, most people at the end of the collaborative process definitely feel like their voice was heard. It was a fair process. They agreed with it.
Right. And I think they get educated and they know why things happen. As opposed to the other way, when you start talking to your family and friends and like, that shouldn't have happened and you shouldn't do that. And, they can say, well, this is, we agreed and this is why. Like, I think you just have a better understanding of how you get from point A to point B. That's true.
And a lot more ownership over the process instead of feeling like you got dragged along kind of kicking and screaming. Instead, it was a process that was framed around what matters to you, what your priorities are, making sure that you were heard about what's important to you, those kinds of things. I mean, those are kind of like the bedrocks of our collaborative cases, whereas that stuff can very easily get lost in a litigation case or may not even be discussed at all. And so,
and to go back to something that you said, Peter, earlier, that in the collaborative process, we don't spend a lot of time strategizing with our clients about we're going to ask for this or this is the approach that we should take. That's not to say that you don't talk to your attorney. I mean, obviously, you should talk to your attorney if you have concerns. Your attorney should reach out to you before meetings and say, is there anything we need to know or anything I need to know going into this next meeting? How are things going? I mean, there should be dialogue between you and your attorney. It's just not strategizing per se,
Mhm.
but concerns, please share your concerns anytime you have them.
It's not as much forming positions and setting up kind of, hard lines that you're going to take with the other side and that kind of thing. That's what we mean by strategizing. It's gathering information between client and attorney and knowing, okay, this is somewhere where you're feeling kind of stuck. Why don't we, make a point of talking about that at the meeting, or maybe between now and our meeting next week, why don't you get with Mark, and see if you can have some conversation. If you're feeling like you're not sure that this option that's on the table will really allow you to make ends meet every month, why don't you just reach out to him offline and just see if there's something more that, that you're not understanding, or that maybe we can tweak it a little bit, those kinds of things should happen between meetings. But strategizing, creating gambits for the other side and things like that's not.
Sure. I have one more question before we wrap up. Are all the conversations the husband and wife or spouse and spouse together, or are they all separate, or do you have a mixture?
So it's a mixture. So I mean, at our meetings, at the full team meetings, both spouses take part in them. But there is often, like we were talking about earlier, kind of sideline things that are going on that may only go on between, one of the spouses and you, Carrie, or one of the spouses and the coach, so no, it really is, it's organic and flexible enough that you really kind of utilize the professionals in whatever way kind of accomplishes the goal of making sure that everybody is fully informed, being heard, their values are being honored, those types of things. And you just kind of organically handle it in the way that best maps onto that.
That's wonderful. That's
Yeah,
wonderful.
want to make sure that people always feel comfortable saying, I'd like to talk to my attorney. I have a question. And you can always break out of a team meeting and say, all right, you and I are just going to talk, Mark, because I know you had some concerns about this before, and then we'll come back and resume the meeting.
Thank you so much. It sounds like we might need to do another one of these because there's just so much to discuss.
Yeah, there is. Yeah, we didn't get a chance to really talk about how things end, what happens afterwards, so yeah, maybe we'll have to. I love talking about collaboratives, but
Might
and
make
with you
part
guys.
3.
Yes, might be a part 3. Thank you so much for having me again, you
Thank
guys.
you for your time.
Thank you.
Thank you for listening to us today. You can find us on the divorcelab.com. You can feel free to take a look at our other episodes, and you can also leave some questions or comments for us on there as well.